Welcome to this week's Q&A. We have a somewhat technical question this week from one of our viewers in Singapore, and they've asked, what are the implications for us if we want to purchase property in Australia, as we are in fact UK citizens. However, we do have Australian permanent residence visas. So it's a really interesting and in-depth question because it revolves around several pieces of legislation, both state and federal. So if you look at it on a broader basis, the Foreign Investment Review Board, the FIRB, is something that people need to consider. So can you purchase only a new dwelling, or can you purchase one that's already been established? And in this situation, most people should be fine to proceed without having to obtain FIRB approval under this situation, because they have permanent resident visas and are therefore not restricted from a time viewpoint in being able to spend time in Australia. But it gets a little bit more intricate, I suppose, when you look at the situation of having to pay a stamp duty surcharge or foreign acquirer's duty on top of the normal stamp duty that someone would have to pay within Australia. And this is always state-based, so stamp duty, as most people know, is state-based and can lead to different outcomes. So if, say, both people are foreign individuals, foreign citizens, but have Australian PR visas, they are in fact possibly treated differently, say, in a state like Queensland from a state like New South Wales. And that has to revolve, or in fact does revolve, around the definitions of who is a foreign individual from both, from various states and territories, and how they go about bringing those guidelines to bear. So in one state you may not have to pay the extra foreign acquirer's duty. In another state you may have to pay that. It's really important, obviously, to get very good and verifiable legal advice before you enter into any contract of sale or transaction with residential property in Australia if you're in that situation. And then we have other situations quite often where one member of the couple, one spouse, is an Australian citizen and the other one isn't, and that can lead to further outcomes where someone might choose to buy something, joint tenants, for example. But again, the laws there then are different if you're buying it as a tenant in common with your husband or wife. So really what it brings out is basically to say, look, get some really good advice in relation to where you're at, because you may have received advice and, for example, you may have your permanent resident visa, you may be a foreign citizen, but you haven't spent more than 200 days in the prior 12 months residing within Australia. So you may have got advice at one point in time and it's stated that you don't have to pay any foreign acquirer's duty, but that may change later on, and unless you update or upgrade that advice, you may actually be caught by something and be caught unawares. Now, if you found this of interest, or if you're in a situation where maybe this applies to you and you'd like to get some more information, then please reach out, email us or call. We can have somebody attend to those needs for you, or recommend some of our panel experts to give you some assistance with that. If you enjoyed this, then please subscribe to our YouTube channel and click like, and I'll see you at next week's Q&A. I'm Andrew Unterweger.